Please, Your Lordship. In item number 3, we have been asked to withdraw the petition, Your Lord.
But to withdraw. But the high bidder.
The petitioner has instructed to withdraw the petition, Your Lordship.
We'll take it up. And the matter is.
Lordship. Other side, I petition item number 11. Senior Mrs. Egan has undergone a surgery, Lordship. And my senior Mrs. Egan has undergone a surgery, Lordship, and is hospitalized. Kindly adjourn the matter for 3 weeks, Lordship.
But I am for
There's
the
been some.
petition, I can it taken up on 17th? 2014, when
Has been submitted by Ms. Lorenzo, appearing on behalf of Ms. Egan, that she is undergoing some surgery, and as such, not in a position to appear before the court. First, accordingly, this matter on 17th of December 2024 at 2 p.m.
Please, your Lordship. Lordship, I beg to mention item number 22. Hearing for Lordship, in this matter, the earlier engaged counsel for the petitioner, N.J. Khatunier, has withdrawn his wakalat now.
Who?
N.J. Khatunier, earlier engaged counsel for the petitioner. So we are newly appointed counsel.
When were you appointed?
We are verbally appointed. We have not filed our
No.
wakalat. Therefore, seeking
You have
one
no
week time to
business.
file our wakalat now.
No business. You remain present when the matter is called.
May I please, your Lordship, I beg to mention item number 7 with the consent of the other side. Lordship, conducting senior counsel, Mr. G.N. Sahewala is out of station.
Huh?
Item
Who?
number 7,
Who is out of station?
Mr. G.N. Sahewala, sir.
For this matter. What about the other counsel? Yes, Mr. Sharma, what do you have to say? You oppose.
the matter has been delayed.
What do you have to say? Otherwise, they don't have a case. Matter has been heard. What remains? Because this matter is tagged with me. So under such circumstances, I can't do this matter before 16th. I have it on 17th then.
From 17, I will be out for medical.
In the month of January. Item number 7, at the request of the learned counsel for the petition, matter stands adjourned to be listed again on 7th of January.
Lordship, there is an interim order.
7th of January. Pusto. The interim order passed earlier shall continue till then.
May please, Your Lordship. My Lord, I beg to mention item number 2025, Your Lordship, supplementary hearing. Complying with the order, Your Lordship, I have filed the additional affidavit against who they have filed a reply, Your Lordship, yesterday only. And my tenure is out of station, Your Lordship. My humble prayer, my Lord, it can be listed next week, any date, Your Lordship. I have taken the consent from the petitioner counsel, Your Lordship.
Didn't that matter?
Yes.
Initiation, madam.
This is part heard, no?
It is part, and we have completed the pleading, Your Lordship.
So if I fix it next week, I'll have to take it from Kohima.
Week thereafter.
You'll meet both of you there in Kohima? Not him. Not him. It is not at his thing. I'll meet you in Kohima.
Any date next Lordship available, because it's a part heard, any date available after 1 month or so, if next. In the principal seat.
But I'll forget.
At the earliest, madam, whenever my lord's the principal seat, madam.
So it is
have to-
almost completed, hearing is almost completed, only few points has to be there.
So
So
Okay,
that
very
All
well.
has already been
He
decided.
can very well argue from there, wherever he is. The question is as regards initiation.
Yes, correct.
His specific case is that there is no initiation. I've asked you to file an additional affidavit.
Yes, we have filed.
Filed it.
And
I
it-
filed my reply. ma'am.
reply yesterday only, it was filed yesterday. I think it is not yet come on record also.
Submitted that additional bit have been filed in this matter. 17th of December. 17,000.
Like,
Deeply obliged. ma'am.
With your lordship's and indulgence, I'd like to mention item 8. We're required to file our affidavit, my lord, we could not prepare it. Your lordship accommodated for 3 weeks' time. I have taken consent of the other side.
Lord, as because 3 weeks, my lord, I have not given consent.
So, Doctor, filing of an affidavit, I can't allow it. At the mentioning hours. Is my. I regulate the court. You want to make some other prayer? I can consider, but not at the.
My lord, I am not ready to say that much like this. For
Let's
2 weeks, my lord, he is having objection for 3 weeks, then let.
No, but I'm not going to grant you an adjournment on the ground of filing of an affidavit, because filing of an affidavit, if I do it, every time this will happen.
I understand.
So this is how I regulate my court. So take a mention when the matter is reached.
I'm obliged.
May I please, Your Lordship? Lordship, with the concern of the other side, in item 21, Lordship, I am praying for an accommodation today, Lordship. Mr. B. Pathak, my lord, is suffering from some eye infection, my lord. Yesterday, I have submitted the adjournment request also, Lordship.
Huh?
Yesterday, I have submitted the adjournment request to the court master also,
Adjournment.
Lordship. Lordship,
You've taken the consent of the other
Lordship, I
side.
have taken the consent.
Matter after 4 weeks.
Obliged, Lordship.
Top of the list, item 1 to 3.
Where is the fair counsel? Mr. Pet Sharma. He said that he is very fair. Didn't he say that?
Well, I am appearing today, my lord, but Mr. Sharma is out of station. I'm appearing.
So you are appearing.
I have the.
So the question involved is there is a requirement of a resolution to be submitted by the council, by the bidder. He is a cooperative society. Whether there was a resolution.
The resolution as such in the record I have not seen. The bid document of the private respondent, bid document of the private respondent contains a certificate by ARCS. It says that the society, it is.
No, no, the authorization has to be by way of a resolution, isn't that? Isn't that the mandate of the rule, the tender condition?
But I have.
Let's see the tender condition. Where is the tender, Mr. Doctor?
Additional affidavit, my lord, page, my lord, 11, my lord. Like last time, lordship, so one resolution is there, but it was not, my lord, by the, my lord,
That is what.
the, one-man officer.
In which case it is there?
In page 11, my lord, my additional affidavit.
Which petition?
Even reply, my lord, 941, my lord.
Page 11?
11, the additional affidavit, my lord. Sorry, even reply, my lord. 941.
19. Yes, all bidders. If the bidder is a member of a cooperative society, then his name and full address. Whether the tender tenderer has the resolution authorizing him to submit the tender is available. Xerox copy of the resolution is to be annexed. So whether there is a resolution, and we are to take into consideration that at that point of time, the particular society was under dissolution.
One-man committee was. In the affidavit filed by the department, paragraph 7, we have stated that we have taken a report from the department and
Let us see the records,
yes,
not the affidavit.
Right.
Mr. Datta, that is only your ground.
That is the only ground I have at this moment, subsist.
He is withdrawing.
He is withdrawn.
they said that the respondent society is a defunct society. That is the ground. A resolution, possibly a resolution in the writ petition I did not find.
What is the name of the respondent society?
But there is a green color flag, Hebrew Dangri,
Huh?
Hebrew Dangri,
Dangri.
means somewhere.
They quoted 3,71,000.
Second high,
The second highest. The second highest.
or third. Highest.
But isn't it the requirement of quoting 10% higher every year? Mr. Datta?
Yes, there is a requirement, but tender condition, my lord, of course, there's a requirement, doesn't say so, but tender, there's a 10% requirement every year to be increased every year. That's the.
Have a look at it. I think that is the requirement of the rules or anything to that effect. Whenever you are quoting, you have to quote 10% every year higher. Because everybody has done that. Except Dibru Part 1 Mean Mohal. Who is he? He has only quoted 8,01,000 for every year. Otherwise, everybody has quoted something higher. Meaning, so here the resolution is not by any government official.
In the record, with the bid document, I have.
There is only one resolution issued by wherein it is under the signature of the secretary as well as the home Sabapati, which will be the chairman.
Once Simanto Tai was, my lord, appointed as the, my lord, one-man committee, madam.
And when was the society dissolved? Your society was dissolved when?
1470, lord, all the members of this one.
Page number 32 of the writ petition. Page number
1417.
17.
And then it was under dissolution till
My lord, it was still about 26 and 919.
26?
Yes, 26 919.
But this resolution is of 2010-2019.
In fact, my lord, on my lord 26/5/17, the board's tenure ended also because 5
No,
years.
no, no,
period
no,
had
no,
also
no, no.
gone.
When was this submitted? Bid was submitted on
Bid was submitted sometimes, my lord, in month of, my lord, opened on, my lord, 24/10, my lord, so it was submitted somewhere near about, my lord. 4/10 is the tender notice.
24/10/2019. Bid was submitted.
The tender notice is 4/10. Tender notice is 4/10, and my lord, bids were opened on 24/10/2019. So
Okay.
in between.
Now, as on 2010-2019, was the society under dissolution?
My lord, the board had already expired on 26/5/17.
When was it again did that happen?
My lord, it was, my lord, on 26/9/19, my lord, the order was set aside. 26/9/19, the order was set aside.
So 26/9/19 the year. So the board again came back.
But the board completed its tenure, my lord, in 2017 itself, my lord. So there ought to be a new board, my lord. The board was elected in 2012. So 5 years period ended in 2017. There was no new election of the board. So there ought to be a new board from 2017. Though the board was dissolved in 2017 before the tenure, but in the meanwhile, the tenure also expired. The board was elected on 27/5/2012. So therefore, its tenure ended, 5 years tenure ended on 26/5/2017. So there ought to have been a
So
new board.
by statutorily, it has come to an end.
It has come to an end. Otherwise also.
And there was no new
No
board.
new board,
constituted.
my lord, there's no
There
rebuttal.
is an order on 26/9/2019.
Yes,
It was by the additional register of cooperative societies. Ultimately, the order has said, the order of Journal Joint Register of Cooperative Societies issued by order number so dated 1/4/2017 is hereby vacated and restored the democratically elected board of directors of Dibru Dongri so and so. But it was dissolved on 1/4/2017, and the appeal was allowed. That order has been set aside on 26th of September 2019. So democratically elected body has been restored. But in the meantime,
But what happens to the statute?
the board which has been restored by the order, they have to take the steps for re-election. They have to take the steps.
No, maybe it has been restored. But can, in view of the embargo and there being no saving in the provisions of the Cooperative Societies Act, could it be said that the board would have been restored after a period of 5 years? It may have been run, but the question is by way of an order. Just for example, I pass an order as a high court also. Could I have restored the board to that position unless the statute mandates?
10 years is already over. But 10 years.
So by statutorily, that board has no longer in existence.
Not. The period, original period
So
is over.
the resolution which was adopted on 2010-2019 cannot be considered to be a resolution of the board. Because by statute, it is no longer there. This is the resolution on which he is submitting.
Yes, okay.
So as on that day, that could not have been. And there was no appointment of a member also. 41(6) was also not there. So in fact, the board was a defunct board by operation of law. Let us see that provisions of the cooperative society. Where is that provision? Term of the board is, directors is 42. The tenure of an office of an elected members of the board and its office bearers shall be 5 years from the date of the election. Provided that the tenure of an office bearer shall be coterminous with the tenure of the board. The term of the representative officer shall be coterminous here, provided that the service shall cease to be a representative of the board where that the representatives of a casual area, provided the board may fill a casual vacancy of a member. So there is a provision which it automatically comes to an end.
The term of board section 31, my lord.
There'll be 5 cooperative years
Yes,
from the date
From
of the
their
election.
election.
So, and there is no extension.
There is no extension.
So there cannot be an extension.
There cannot.
So if there cannot be an extension, that means there is no resolution. Yes, Mr. N.K. Kolita, what do you have to say?
Society could not provide me the date of election. That is why I am not able to say about that. But my lord, board was defunct on my lord 1/17. Within 2 years, that order was challenged before the register property society, my lord. And accordingly, my lord, it was that order was set aside and democratically, my lord, the elected body was restored. That order has not been challenged by anybody.
So what? The operation of law you cannot be there. See, the moment it is restoring, one thing good for you is that you don't get disqualified under 41. That is another aspect. For not holding the elections within 39 and all these things are not there. But how do you take care of a situation where the board does not exist?
Term of the board is 5 years. But the last election, that I am not aware. That is why.
Are you not the member of that society?
Yes, madam.
And you are not aware?
Because they could not, he could not provide me that instruction because he is suffering from some illness, some incurable disease. That is
Are you running it?
Yes.
We cancel it with state. You run it through whatever may be, with state. Because you can't come up with this type of a excuse. When the matter last time came up, I gave you the opportunity to that. But this can't happen. It is absolutely
There's
illegal.
a specific amendment, my lord, that came on, will be made.
Then there is no reply to that.
That's not a rebuttal. Page 9 of our writ petition.
Elected on 27/5/2012.
You are, what is your name?
My lord, I'm
Fodia.
Fodia, my lord.
Fodia Soikua.
Yes.
You did not submit the fishing experience certificate.
my lord, that is what this, my lord, say, but will we say, my lord, that,
You did not submit a pen or any certificate from the competent authority.
that is, my lord, there, my lord, but we have, my lord, made a submission for saying that, my lord, that,
You did not submit the neighborhood certificate. Then
that is the ground on which we rejected, my lord, but we have been under affidavit, my lord, reply to that, my lord, those allegations, my lord.
what did you say?
My lord, in fact, my lord, in my lord, paragraph, my lord, 9, while my lord dealing with the rejection, my lord,
Oh. Mr. Dotto. No certificate.
no, these certificates were not submitted, my lord.
Then,
That is there.
and what do you say on the proposition that a tenderer who is otherwise not qualified cannot challenge the tender?
My lord,
You are no longer, you don't come within the ambit of that.
but our contention, my lord, was that, so far as the income tax certificate, etc., was not required, because, my lord, income tax certificate was concerned, it was not required, my lord. Because there is a circular of the income tax department, my lord, that it is, no, my lord, not required.
What?
There is a circular of the income tax department, my lord.
That-
which we have annexed, my lord. That, for the purposes of, my lord, this is not required, my lord. And, my lord, so far as the neighborhood is concerned, my lord, our contention is, my lord, that since the, assessment is to be made, verification is to be made with the
They
authority.
have asked for a neighborhood certificate.
That's true, my lord. But then,
Then
so fact, we did not submit, my lord. That cannot be denied. But annexure E, F, my lord, of my page 29 of my petition, my lord, we have relied upon a circular of the income tax department, my lord.
Issue as regards submission, non-submission of the neighborhood certificate by the petitioner. It is reflected in the honorable court order on 6/6/24. There is order passed by on 6/6.
I think there, I've seen it. He has not submitted 3 documents. No PAN card, nothing to the effect.
The neighborhood has been already decided.
So what do you say, Mr. Kulija?
There was another petition, my lord, petition 3225 of 17. In that case, the honorable court was, direct the authority not to alter the voter list, my lord. In the mean, and pursuant to that, my lord, one IA was filed on, bearing number 685 of 2020, seeking leave of this honorable court to hold the, my lord, ACFL. That IA was pending, my lord, but it is still pending.
In your case?
Yes, ma'am.
And there is no appointment of a one-man committee. So you have been allowed to run. There is no challenge to that. He is an ineligible voter.
My lord.
And he is working out. So there has been something which that person concerned have been with 8 lakhs.
Yes.
I can't help more than what is there. Yeah, you are not a eligible bidder. If you were not an eligible bidder, you cannot challenge. Isn't it the law?
But none of them, it appears neither he is eligible, my lord. So therefore, my lord,
He is eligible.
Yes.
He would be eligible taking into account there is no challenge that he is continuing. There is no challenge by anybody. Neither the Register of Cooperative Societies has appointed a 41-6.
But then, by,
Allowed it, yes, as per law, they could not have.
so my lord, it's
But
a,
why should I
it's my
go
lord,
to
it's a,
that
it's a, my lord, it's a, my
when
lord,
you are not eligible?
it's a settlement to a society.
If
my
you
lord.
were eligible, I would have taken up that. You are not.
Well, he was given an opportunity, my lord, to rectify the Bakija certificate. That was also not there. So, my lord, he was given an opportunity to rectify the Bakija certificate, which he did not submit. Because it was in the name of the person concerned, not the society. Then, my lord, it was clarified and it was accepted. Then in that, my lord, event, my lord, we could also have been given an opportunity, my lord, submit the documents, my lord, to other documents, my lord, if, at all, my lord. If he was given the opportunity, my lord, we also have got to have an opportunity to submit those documents, my lord.
Too late in the day, Mr.
That is, of course, well, on the ground we have taken, well, that he was given an opportunity which we are deprived of. And well, that Millard certificate, also they have clarified, Millard, it was given later on, Millard. It was, Millard, it is an admitted position that it was submitted in the name of the person concerned, not in the name of the society. And the spot verification, I was found in the neighborhood. Well, that aspect was taken care of.
Has it been finalized? Means, was there any interim order?
Millard, no interim order.
He was not given, he had a neighborhood, he did not submit the neighborhood certificate.
His case was that a verification, spot verification was not done.
He cases that there is no neighborhood certificate.
And Millard, there's no spot verification done with regard to his fellow society. It was only done with regard to me and Millard, the private respondent, Millard. And which was a requirement, Millard, under the circular, Millard, that they ought to have, Millard, verified the neighborhood of the societies participating in the process. On the other
No,
hand, Millard,
it is not that he did not submit a Bakizai certificate.
he submitted, but it
He
was in the name of the
submitted the
person
Bakizai
concerned.
certificate in the name of the secretary.
Second,
But later on, it was corrected and given.
because Millard, it has to be,
But you did not submit.
Millard, I submitted, Millard, a certificate issued by the Assistant Register of Cooperative Societies for Fishing Experience, page 28, Millard. And Millard, I was relying upon that Income Tax Department circular, Millard, which Millard abolished the requirement of submitting IT clearance certificate. And so far the neighborhood is concerned, Millard, our case, categorical stand was that Millard, the Deputy Commissioner has to make an assessment of the Millard neighborhood, Millard. So
You have to take a name. When the tender says that there is a, you should have then challenged the tender condition.
that is of course there.
How did he give the neighborhood certificate?
Well, that is there, Millard. I did not submit that. I cannot, Millard, to improve upon, Millard.
What do you want to do? Withdraw. And these are the two repetitions. What about, there is another one?
There is another one challenging a subsequent, Millard, that order of fresh re-verification.
Huh?
Two repetitions filed by.
By me.
Same petitioner has filed two repetitions. And the other filed by.
Why did you file two?
Second one, Millard, with regard to the fresh re-verification process that was, Millard, sought to be initiated by 5th August 2020, Millard communication, that we had challenged.
Why?
That we had challenged, Millard, saying, Millard, that the process in itself, Millard,
What is that number?
That is, my lord, application number 3408.
How is this connected?
Same, my lord, the process, my lord.
Huh?
During the process, my lord, another issue, letter was issued on 5/8/2020, page 30, my lord.
Hmm.
For fresh, my lord, spot verification, after the tenders, my lord, were settled, my lord.
And he has been running from when?
1000, my lord. No, 16, this 19, this 7/19.
So they wanted to go for a neighborhood assessment. So why you are challenging that?
That was challenged, my lord.
First of all, you don't submit the neighborhood certificate. Then they go for this, that also you challenge. Where will the fishery department go?
It was done, already done, my lord, thereafter. So this has become infectious in any case, my lord. This is, and that's what, that's the reason that I'm.
So the learned council. WPC 3408/2000. Actuals. Communication dated 5/8/2020. Verification was duly conducted. Taking into account. Instance that's closed. It's Baki Dukon Day.
But one thing that I just have to bring to your. So there is subsequent order on 14 September 2020, by which the order which was passed in 26/9/2019, that was withdrawn. And one-man committee was appointed under 41 CS.
Then?
Then till the re-election. Till the new election we conducted by the society,
Yeah.
their society. One-man committee was appointed again on 14 September 2020.
2020.
2020.
Then?
From 26/9/2019 till 14 September 2020, their board, it was registered. They continued. In the meantime, the process was there. That order, Lordship will find in the other writ petition, it is a part of the
14.
14/9/2020.
Lordship will was restored when?
It was, I'm giving the date, 26/9/2019. The board of director was restored.
There.
There.
Your neighbor.
There. One of the private respondent, to whom we have given the settlement.
And then he continued till?
Till 14/9/2020, The order says
And on 14/9, one-man committee.
14/9/2020. Now in exercise of power conferred under section 41(6) of the Cooperative Societies Act, Simanta Taye, Junior Inspector of Cooperative Society, is hereby appointed as an officer to manage the affairs of the society till formation of the new board of directors. That logic will find at page 26.
So as on that date, this board was functioning.
That board was there.
Okay.
As on that-
Anyway, this person is not eligible, can't help it.
And it's a tender matter, Lordship will interfere when it's a tender matter. The authority, after going through all the documents, they have taken a decision. Lordship will interfere with the decision if judicial review will lie, only if Lordship finds any arbitrariness on the part.
Mr. Dean, I hope my mic is very clear. Mr. M. Dutto knows the fate of his reputation.
But
But Mr. M. Dutto, the learned counsel, appearing on behalf of the petitioner in WPC number 941/2020. And Mr. So appears on behalf of the writ petitioner in WPC number 737/2022. Mr. D. Nath, the learned senior government advocate, also appears on behalf of the Fishery Department of the Government of Assam Mr. N.K. Kolita, the learned counsel, appears on behalf of the private respondent. At the outset, it is relevant to take note of that Mr. So-and-so is an honor. Mr. So-and-so, appearing on behalf of the writ petitioner in WPC number 737 of the 2022, had submitted that the writ petition has become infructuous. Had submitted that the petitioner had given instructions to him to withdraw the instant writ petition. Thus, taking into account the said submission, the instant writ petition stands closed on withdrawal. Thus, in the said backdrop, therefore, the writ petition which requires adjudication is WPC number 941 of 2020. Thus, to decide the legality, the petitioner herein have assailed the order dated 26/12/2019, whereby the Brahmaputra Part 1 and the Dibang River Fishery was settled with the respondent, with the private respondent for a period of 7 years. 7 years. First, for the petitioner have challenged the legality of the said order. To ascertain the legality, to ascertain as to whether in the present facts, this court should exercise its powers under Article 2 to 6 of the Constitution. It is relevant to briefly take note of the facts which led to the filing of the instant writ petition. From a perusal of the materials on record, it reveals that on 4/10/2019, a sale notice was issued by the Additional Deputy Commissioner in charge Kodia Subdivision for settlement of the Brahmaputra Part 1 and Dibang River Fishery for a period of 7 years, that is from 2019-20 to 2025-26 by a tender system. Brahmaputra Part 1 and Dibang River Fishery, the fishery in question. Pursuant to the said bid, 5 tenders had submitted the bids. They were number 1, MS Dibru Part 1 MSS Limited. Number 2, MS Dibru Dangori River Part 1 MSS Limited. That's the private respondent. Number 3, MS Kodia Saikwa MSS Limited. That's writ petitioner. Number 4, MS Rongagora FCS Limited. Number 5, MS Dibrugarh FCS Limited. Upon such tenders being submitted and being scrutinized, it was found that MS Dibru Part 1 MSS Limited did not submit the neighborhood certificate in terms with clause 2 of the notice inviting tender. The petitioner, who offered the third highest bid, did not submit now, Roman 1 fishing experience certificate as required under clause 4 bracket core of the note NIT. Roman 2 pen or any certificate from the competent authority of the IT department in terms with clause 4 SAW CHA bracket close of the NIT. And Roman 3 neighborhood certificate in terms with clause 2 of the NIT. The MS next. MS Rongagora FCS Limited, who was the fourth highest bidder, did not submit the call deposit as well as had submitted an expired Bakizai certificate as on the date of submission of the tender. Next. MS Dibrugarh FCS Limited, who offered the fifth highest bid of rupees bid, did not submit Roman 1 call deposit in terms with clause 4 ungo to bracket out. Number 2, fishery experience certificate in terms with clause 4 core. Number 3, 100% actual fisherman certificate in terms with clause 2. No numerical today. Roman 4, Bakizai certificate in terms with clause 4 core. And number 5, pen in terms with clause 4 SAW CH. However, as regards the private respondent who submitted the second highest bid, had submitted all the documents in terms with the NIT, except the Bakizai certificate, which was submitted, was in the name of the secretary of the society. Subsequently, the society had submitted a petition dated 7/12/2019, along with a copy of the certificate issued by the ADC Tinsukia, dated 4/6/12/2019, to the effect that the certificate issued to the society dated 21/10/2019 was in the name of the secretary of the society, instead in the name of the society due to technical mistake. The said certificate dated 6/12/2019 clarified that the certificate dated 21/10/2019 may be treated in the name of the society. On the basis of the above, the tender committee, after making scrutiny, found that except the private respondent, the bids of all other tenderers were not valid in terms with the NIT. And accordingly, by an order dated 26/12/2019, it was decided that the fishery in question would be settled with the private respondent at the bid value of rupees 25,97,000 for 7 years as the highest valid bidder in terms with the NIT. The petitioner, it is under such circumstances the petitioner had approached this court and filed the present petition. The record further reveals that various pleadings have been filed in the instant proceedings by the private respondent as well as by the state respondents. Full stop. The reference to the same shall be made while dealing with the respective submissions made by the councils appearing on behalf of the parties. Full stop. Mr. M. Dotto, next, contentions of the parties. Mr. M. Dotto, the learned counsel appearing on behalf of the petitioner, submitted that in terms with the NIT, there was a requirement submitted that that taking into account where the Fishery Act, take into account Rule 12 Rule 12 of the Assam Fishery Rules 1953. In the tender application, in the notice inviting tender, there was a mandate, there was a requirement that if a bidder is a member of a cooperative society, then his name and full address is required to be submitted. In addition to that, the resolution authorizing the person to submit the bid on behalf of the cooperative society is also required to be submitted. The learned counsel submitted that the respondent, private respondent society is a cooperative society, and on, what is the date? 2017? It's 2017, you say the date, na?
Date, yes, Madam.
Yes.
It's 26/5/2017.
When on 26/5/2017, the said private respondent, the society was dissolved by an
Sorry, ma'am,
order
dissolution is 1/4/17.
who was on 1/4/2017, 1/4
One.
2017, the society was dissolved. Full stop. This dissolution was put to challenge before the Register of Cooperative Society, and the Assistant Register of Cooperative Society, by an order dated 26/9/2019, had set aside the said dissolution. The learned counsel, referring to Section 31 of the Assam Cooperative Societies Act 2007, read with Section 42 of the said Act of 2007, submitted that a society, the tenure of a society is only for 5 years. And as the society, from 5 years from the date of its election, the learned counsel submitted that the date of election of the said society was on
27/5/2012.
27/5/2012, and as such, by operation of law, the society was dissolved as on 26/5/2017. Full stop. Therefore, the resolution which have been submitted dated 2010-2019 was a non-est document for which the said document, for which the tender of the respondent, private respondent, ought to have been rejected by the authorities concerned. Anything more? He further submitted that the respondent authorities have also differentially treated the petitioner by not giving an opportunity to the petitioner to remedy the defects in its tender, though the private respondent was given such an opportunity. Full stop. Mr. Dinath, the learned counsel appearing on behalf of the Fishery Department submitted that that by an order dated 26/9/2019, the order by which the respondent society was dissolved was set aside and thereby restored the board of the directors. Full stop. The learned counsel submitted that immediately thereupon, on 20/10/2019, the resolution was adopted whereby the secretary of the said society was authorized to submit the tender. He further submitted that this very resolution was submitted by the private respondent along with the bid. The learned government council further submitted that there is no challenge to the said resolution. There is no challenge to the said resolution, as well as there is no challenge to the work to the order dated 26/9/2019, by which the board of the private respondent society was restored. Full stop. He further submitted that it was only on 14/9/2020, the one-man committee was appointed by the Corporation Department in terms with Section 41(6) of the Act of 2007. He therefore submitted that the question of the private respondent did not have, that the submission of the tender by the private respondent was not in terms with the notice inviting tender did not arise. In addition to that, the learned counsel submitted that the question of differential treatment to the petitioner vis-a-vis the private respondent did not arise, inasmuch as the petitioner did not submit the various documents which the petitioner was required to submit. On the other hand, the private respondent had duly submitted the Bakizai certificate. However, it was only, the said Bakizai certificate being in the name of the secretary, the same was duly rectified with, the same was clarified by the ADC by his letter dated 6/12/2019. Full stop. What do you have to say?
Submission.
Mr. N.K. Kolita, the learned counsel appearing on behalf of the private respondent, had made similar submission to what had been made by Mr. D. Nath, the learned senior government advocate. And for the sake of brevity and to avoid repetition, this court is not reiterating the same. In the backdrop of the above submissions, No. This court have duly heard the learned counsel appearing on behalf of the petitioner as well as the private respondents, and have also perused the materials on record, including the records which were directed to be produced. Full stop. From a perusal of the records so produced by Mr. D. Nath during the course of the hearing, it appears that a resolution dated 20/10/2019 was duly submitted by the private respondent. It is also clear that on 26/9/2019, the said private respondent society was reinstated by the Corporation Department. Full stop. There is no challenge to the said reinstatement of the board of directors of the private respondent by any person. Full stop. In addition to that, there is also no challenge to the to the resolution dated 20/10/2019. Full stop. the authorities concerned have duly taken note of that said tender dated 2010 the resolution dated 2010-2019 and have accepted the same to be in conformity with the tender conditions. Under such circumstances, this court would not like to exercise its under such circumstances, this court would not like to exercise its powers of judicial review, taking into account that the respondent authorities have duly taken into consideration the said resolution dated 2010-2019, which which held the field, and there was no challenge to the said resolution. Now, coming to the question of differential treatment, it is seen that the case of the petitioner is completely different from that of the private respondent. The petitioner admittedly did not submit the various documents as stated herein above, which were requisite documents to be submitted along with the tender documents. On the other hand, the private respondent duly submitted the Bakizai certificate and the subsequent clarification Bakizai certificate. Full stop. It is, however, the tender authority, however, in its discretion had accepted the said clarification. The acceptance of the said clarification at a subsequent stage being within the realm of the tender committee, it would not be proper on the part of this court to exercise the powers under Article 2 to 6 of the Constitution in the present facts. Accordingly, this court finds no ground for interference with the impugned settlement dated 26/12/2019 made in favor of the private respondent, for which the writ petition stands dismissed. So the record so produced is returned to Mr. Dina.
Obliged.
Yes, if Lordship directed last occasion, and this is, I think for the simple matters where the allottees, they are starting their business and COVID-19, they are dislodged by private respondent and they are evicted, then
Where are you? Consider the municipal market dealer. Where? El Petan?
help better. We are given, my lord, space.
What has happened? They are throwing you out. Yes, Mr. Bora, what is his case?
They were allotted, my lord.
Huh?
The space in the setback. To do temporarily, they were allotted to the business of. And when the COVID has come, they stop their business. In the meantime, some other person has entered. And we have already done eviction, then cleared it. They are doing their business. They still say some other person is still sitting and doing their business in their particular
So
portion.
what is their prayer here?
And his prayer is to evict them and hand over our possession.
That has already been done. My lord. They still say that there is some person.
Prayer for
That can be done.
17 days.
Now, who are the outsiders?
My lord, they are anonymous. After that, when they are evicted, they implemented. And after that, they file an affidavit, says that no notice was given to us. So we implemented. Now they rely upon that their grievances made up by the another order, my lord, of this honorable court. They said that you are the street vendors and a TVC, town vending committee will allot a land and there you are be accommodated.
So you were the first allotments.
We are as a fire victims, as per direction of this honorable court. they have issued this or permission to use the space. We are settled there, depositing everything. But
So you were allotted how?
my lord, in 2007, my lord, we have filed a case that
That I know. That I know.
we have allotted, my lord, page 21, 22. There is a case, my lord, 2254. On the direction of this court and approval of the administrator of GMC, we have given allotment on that.
You were given allotment.
Yes.
Where is that allotment?
My lord, page 36, my lord. Annexure D.
Some of the, there are 4 or 5 orders. 4.
Annexure D, my lord. Some of this I have annexed.
So these are the people who have been allotted.
Yes, my lord.
Now you have been allotted for how long?
My lord, how long that is not mentioned, my lord?
It is mentioned clearly.
Yes,
Yearly.
Number one.
yes,
Yearly.
yearly. Yearly.
Then
No, my lord, during this pendency, my lord, what happened? Due to some COVID, they decided to suspend this business in Fancy Bazaar, my lord. The whole thing is, my lord, empty. Some others occupied there when the COVID is out, my lord, as per
so
their.
it is a dispute between you and them.
My lord,
Where is your right to continue?
their cause of action is different. In their affidavit, their direction is given that allot them to a suitable place by town vending committee. So town vending committee has not notified this area as the town vending zone. So their cause of action is different, my lord. 7,000 similarly situated persons waiting to get a suitable land. In Pamuhi also, it is allotted, my lord. They are not inclined to go there.
Understood, but where is your right? This court can only pass a direction when you have a right.
Yes.
Can a right be created on the basis of an order passed by court?
Yes, my lord, page 22, my lord, there is a mention. And they categorize as category 2, my lord, page 22. This was the repetition when this anomalies was near
The
to the
direction
5
given to the year permitting it to make
My
allotment
lord,
in terms of
para 11.
petition have been given. The petition on the big.
This
Please,
was five.
kindly come to paragraph 11, page
Ye-
27.
Yes, there is 2 category, my lord, and those license were at that time fire incident took place. They are in force. They have the priority basis category 1. That was given.
You are
Others,
category 1.
we are not category 1, my lord. We are waiting. Category 2 list should be directed to finalize. After finalization, their accommodation is given. And the whole market is,
Mr. Bora, what are you doing? Means why you are not regulating yourself properly?
and they finalize the list
Something
of
has to
category
be
2
done.
in
Need to
20.
be done, my lord. It had as per the
In-
resolution, my lord, these people were accommodated for livelihood. They will start a small business, temporary business only for fruits. Then they continue. COVID came, they abandoned the portion. Then after the easing out the COVID, they
They
came
did
up
not abandon, you made them abandon.
during COVID.
You
there is
came
no-
up with all this disaster management thing. You did not allow anybody to vend.
That was there, my lord. In the
Then
meantime, the
They
COVID
did not
when
abandon, they were compelled to abandon.
the situation was there such.
Then after that, Mr. Goswami entered.
No, Mr. Not there before. There nobody, but some other person entered. Then the
So those persons are not before this court.
those person are there. Those person are part that then eviction took place. They were thrown out. They were put in that particular portion. And they're doing this. Still they say there are some other persons are working. So some other persons are doing their business. Still we can take and we can if those person who are without
But
trade
the
license.
fact is, how do you regulate them? Because these are street vendors now. You know,
Yeah.
well,
We are not street vendors.
you are street vendors. You have no business out
Yes.
there.
Yes.
Anybody outside the building out there, they are street
No, we
vendors.
are not never outside. We are inside. That is the problem, my lord. We are in the vicinity of the fire.
You have been allotted an area inside the
Inside,
campus.
yes, inside.
But then also you are a street vendor. You are just doing the business outside,
No,
not inside the building.
we are in Masqua, my lord. From Masqua, when
You are
rehabilitation.
not doing a business inside the building.
inside the building, open space, we are not allotted the rooms, but category 1 is given room. Then that if decision, the category 2 should be, list was prepared, they should be given the open space inside the market. We're doing business from many years, before the fire incidents. That is why they prepare the list category 2, they given. Now, outsiders of street vendors also one day inside this. That is the problem.
So somebody else have come inside.
Yes, they want to come inside and equal status with us.
So you are concerned within a confined area.
Yes, inside the railing, campus, inside.
They are not street vendors.
We are not staying, but we are category 2 fire. Well, that's sports is.
Then why are you not able to regulate? For the court to pass
there are-
orders for that.
There are 61 or 61% or 81%, they are needing, they are giving, they are given allotment inside the railing for doing their livelihood, my lord. That's all. That too only foods. And situation has come that that was evicted, my lord.
Nothing means.
Nothing, actually nothing is there. If they say that there is some other person doing illegally business, will they take a drive, check out all the documents, my lord?
And what is Mr. Gusami doing?
We are there, my lord.
You are also inside. They have been also allotted.
But they will have to check. They say they are also doing business in that. But these are people,
Have you allotted? Do you have any records of allotment?
because allotment, lots of will suppress number 36 onwards. That allotment letter, at least they should have it. Those persons who are
So
having
those
allotment
who
letter,
do not have that allotment in your records, sue them out.
they will take, the eviction will have to be there.
You can do inside the business of a particular authority. Yes, you may do outside the road, you do it. But inside the campus of JMC can be done only by a person who have been allotted.
That's all.
We-
Lord, that can be done, my lord. That,
My lord,
one eviction has taken place. I will,
You verify who has the
Yes,
allotment as per
that-
your record.
that-
And who does not have, take
They will have to
appropriate
be-
action.
accept.
Who is the second petition, Nazra?
Second petition is inside. This is not related to the first one.
It is
This will be-
category,
This
second,
should be separated.
second and third.
Second and third is different.
It is
What are
category
these?
1, man.
What are
Category
these? Who are these petitioner? You are there.
Yes, they file with this, my lord. This is category 2 and category 1. They have the license, they have
Inside.
given. But
Inside
there
the
is
building.
scarcity of room. And that is why they are dropped out. The dropped out petitioners now approach this honorable court. Honorable court says that he make a accommodation. That was
Where?
not done. That's-
Go there. You have allotted some people there, na? Lokra.
Dokra is something different. Some land has been allotted. They are,
Ending.
You don't have a room. Where are you going to do?
they are, that particular building, at present, there is no room.
My lord,
They say,
I've already passed an order for those
yes,
people.
those
No,
people
my
is
lord.
there is effective.
That is already there.
my lord,
One order is there. Now means
my lord, one thing, my lord, in court, my learned friend says that he filed an affidavit. But I check it, it is not with my records, then said that at court, in court premises, he is supposed to give me the copy. Suppose, probably I have not received. And another petition, my lord, item number 5, no affidavit is filed. So
Item number
I,
5 affidavit in file.
okay,
so
Peter.
it should be taken in.
Yes.
Yes.
Mr. Bora, this is a case of
551 affidavit in file.
Mr. Bora, this is a case how this court will wash its hands for the day.
So my lord,
Thus will dispose of the item number 4, that
Four,
action
my
will be
lord.
taken. And
4, my lord.
Item number 4, yes.
for inside.
Item number 4.
So first of all, do you have allotment?
We have not, we have been surveyed, my lord, that list.
No. For serving, no serving doesn't arise. You cannot do any business inside the campus of the GMC unless you have been permitted. Matter in.
That is, my lord, that's a fact.
Take a call. Whoever is there may verify,
Yes.
whoever has the allotment as per your reports.
That, my lord, the authority
And
will-
who does not have
Not-
any allotment,
Not-
put them out.
Not-
They can very well apply for allotment if they think so.
It is they are able to tell.
And then permit.
Only one thing, but here, they have come as a registered society, my lord. But that society, my lord, expired in, their registration expired in 1991, my certificate in my lord. This exists, my lord, this society.
My lord, these are the petitioners with the registration, my lord. Now, issue is that the allottees should be allowed to do business or not. Now they cite that the association.
But whatever may be, there are petitioner number 226.
Yes.
There are some. There are petitioner number 326. Two is related to one.
Maybe, but 226 is there. We have been allotted. So for them also, we can take an action. Let us not go into the question of locus then. Question is, first of all, when it is a property of the GMC, inside the GMC property, anybody doing business has to be allotted or given some permission by the GMC to do. If they don't have, throw them out.
That's all. And my note, one other thing that I would like to point out, my note, at page 83 of my affidavit, my note, direction passed in a writ petition that we have filed earlier in the year 2015, my note. Which, my note, I'll just read out at page 83. Under such circumstances, this writ petition is disposed of with the direction to the respondent corporation that in the event the land is allotted for specific purpose of accommodating this with vendors in WPC number 65014. The GMC shall consider the accommodation of the members of the present committee, that is us, my lord. Page 82, and the said members of the committee shall abide by the terms and conditions to be imposed by the GMC for allowing them to vend on the said allotted land. Further, it is also directed to respondent numbers 1 and 2 to consider the direction of this proposal.
Now the question is, have they granted you an allotment?
In that them.
Why you are not filing contempt?
I don't,
This is non-compliance with disorder, but does it mean that you shall usurp your power, the powers of the GMC and just go inside?
we were continuing to do business there.
No, you can't continue to do business. This is absolutely illegal trespassing.
This order
You,
was.
Mr. Bora, you have to be strict. I think that the GMC has a problem of not being strict or selectively strict.
Sometimes it is too strict, my lord. Then about, they are too strict also sometimes. Now the eviction has taken place. Now we'll do a second time, check up all this, the document and there to do the eviction.
Make a verification and do whatever you will do. And who doesn't dare, they can very well apply. They can, if they want, they can very well get these things. This is not their petition before us. It's their petition. They say that we are vendors, we have been allotted. And as such, there should not be anybody else. On the public interest also, the question arises is, can in a GMC property, there can be anybody else vending without taking permission? Yes, there might be people who are outside. Outside the premises means outside the campus of the building. If there is anybody outside, then the Street Vendors Act really applies. For that, you have to take care of another issue. But for that, you cannot make the people inside, because otherwise there will rule of law or any, there should be a case of anarchy. And this is what is happening.
But
Isn't it?
I will take action accordingly.
Mr. Borwa, isn't it the case? It's a case of anarchy.
Yes, my lord. Well, muscle power is less, their muscle power is more.
You're not still reminded. You're not still reminded
So-
of muscle
So,
power.
so GMC will protect us, his honorable court will protect us, otherwise.
No, I am not going to protect you, or GMC has to protect you. The first is GMC cannot permit anybody else inside the campus of the building without there being an allotment, for which the GMC has to take action. Heard Mr. M.J. Bulwa, the learned counsel appearing on behalf of the petitioner. S. Bora appears on behalf of the respondent number
1 to 4.
4. Gusami appears on behalf of the respondent number 5. The case of the petitioner herein is that the petitioner, number 1, is a society registered under the provisions of the Societies Registration Act 1860. The petitioner number 2 to 6 are, it's the members of the petitioner number 1. In the year 1989, more particularly on 22/2/1989, a fire incident took place in the Fancy Bazaar GMC market, rendering hundreds of traders jobless who were the victims of the said fire incident and traders jobless. The said fire victims formed an association to raise the common grievances and protect the interests of the fire victims, particularly known as the Fancy Bazaar Municipal Market Dealers Association. The said association thereupon took steps against made various representations before the GMC. However, as there was no positive outcome, a writ petition was filed in the year 2007, which was registered and numbered as WPC number 225. A writ petition was filed being registered as CR number 281/1989. The said writ petition was disposed of by this court by an order dated 3/4/1989. In terms of the said order so passed in the writ petition, there was a direction to the GMC authorities for completion of the multi-storied building, and the persons who were entitled to do business at the Masqua temporary market would be settled at the multi-storied building come office complex at the Fancy Bazaar and Masqua temporary, and the Masqua temporary would be vacated thereafter. It is also seen that subsequent thereto, there were two more writ petitions filed in the year 1998 and 2000, which were registered as CR number 5290/1998 and WPC number 4586/2000. The said writ petitions were disposed of by this court, whereby two categories of victims were culled out. First were those, the category 1 victims were those who had licenses, isn't it?
Yes, valid license, not.
Who had valid licenses. And category 2 victims were those persons who had license but their license expired. This court in the order passed in CR number 5290/1998 and WPC number 4586/2000 directed that those persons in category 1 should be given allotment on priority basis. Thereupon, the GMC authorities floated a public notice on 2/4/2007, by which 61 numbers of vendors, hawkers who were not fire victims were sought to be settled. The petitioner association herein challenged the same by filing a writ petition being WPC number 2254/2007, which was disposed of with a direction to the respondents' authorities to give settlement to the vendors in the L pattern along the TRP road and the MS road by judgment and order dated 18/9/2007. Paragraph number 8, 9, 10, and 11 of the order dated 18/9/2007, passed in WPC number 2254/2007, being relevant, is reproduced here in under. It's 28, 29, 27. Subsequent thereto, the members of the petition association, along with the respondent which included the petition number 2 to 6, were issued permission, issued allotments for use of open space at the inner side of the railing of the GMC market at Fitzwizard. Full stop. This happened sometime in the year 2020. However, while the members of the petitioner association continued to carry on their business, the COVID pandemic resulted, and they had to abandon their area in view of the various curbs brought in by the Disaster Revenue and Disaster Management Department of the government of Assam. This resulted in certain trespassing being done within the premises of the GMC, within the premises of the inner side of the railing of the GMC market at Fancy Bazaar. The petitioners thereupon represented before the respondent authorities to take appropriate steps for eviction of them so that the petitioners could continue to carry on their business peacefully without any hindrance. However, as nothing was done as alleged by the petitioner, the instant the petition was filed. This court have also taken note of the affidavits so filed by both the respondent authorities. Did you file? As well as also by the private respondent number 5. First, in the affidavit filed by the respondent number 3, it was mentioned that that pursuant to the representations so submitted by the petitioner association, the respondent authorities have taken due steps, and the members of the respondent number 5 were evicted. They were evicted, na?
They were evicted, my lord. Particular date is eviction took place on 17/1/2023. Though it is not in the affidavit, my lord.
17 on the first
17
week of January.
First week, second, it's the third week, 17.
That stopped the members of the respondent area from trading in the first week of January, and then again on the second week of May. Where the members of the respondent number 5 were stopped from trading in the first week of January 2013, and then again in the second week of May 2023. January 2023, and then again in the second week of May 2023. was however mentioned in the affidavit that the licenses of the members of the petitioner association have also expired. And as such, there's the difference between the members of the petitioner association along with the members of the respondent number 5 association had eroded, isn't it? It is, however, seen from the affidavit so filed by the respondent number 5 that the members of the respondent number 5 are vegetable vendors who are mostly residents of nearby villages of the Guwahati city. And they used to sell vegetables bringing from their respective villages in the early morning and continue their trade till noon over the vacant spaces by paying taxes to the JMC. It is the further case that the GMC authorities have caused harassment to them for carrying on their business, which compelled them to file the writ petition, being WPC number 7120/2015. It is further seen that the coordinate bench of this court on 29/2019 had passed an order, thereby directing the JMC authorities that in the event the land is allotted for specific purpose of accommodating the street vendors in WPC number 6546/2014, the JMC shall consider the accommodation of the members of the respondent number 5 and the members of the respondent number 5 shall abide by the terms and conditions to be imposed by the JMC from allowing them to vend on the said allotted land. In the backdrop of the above facts, this court have duly heard the learned counsels appearing on behalf of the parties. Now, full stop. In addition to that, in the affidavit filed by the respondent number 5, there is a list enclosed wherein certain persons, names of certain persons have been mentioned who are unauthorized vendors at the inner railing of the Fancy Bazaar Municipal Market as Annexure 10.
I don't. Yeah, earlier case also, they file affidavit GMC authorities and there they admitted that we are in the, that building that inside the railing setback zone. Like, this is recorded in the, at page.
Understood, but whether you have been given any
Yeah,
permission,
but they had admitted that we were there from before, madam.
maybe you are there, you were there, were you there before 89? Question is, were you there before 89?
They'll verify, man, because they don't have any papers, nothing. But
No, no,
they-
first of all, without there being an allotment, there you cannot. This court have heard the learned counsels appearing on behalf of the parties at length and have given anxious consideration to the materials on record. Also, upon hearing these counsels, this court had inquired with the learned counsels, standing counsel of the JMC. As regards the Fancy Bazaar Municipal Market, as well as the inner side of the railway railing of the GMC market, which is the subject matter of consideration before this court. Mr. as per the learned standing council submitted that pursuant to the fire in the year 1989, the GMC authorities have constructed a multi-storied building. The said multi-storied building is situated upon a land and the building stands upon a land which is encompassed with a boundary
Really,
of railing. Encompassed by a railing. In the setback areas of the said multi-story building, the members of the petitioner association have been granted permission
Open space.
for use of the open space.
only foods, no foods, temple.
Use of the open space. And each of such members have been specifically allotted an area with number. Specifically identified. Allotted, specifically identified with a number. In that regard, he referred to page 36 of the petition, which is the Annexure D series, and apprised this court that the petitioner number 2, is it 2? Petition number 3 was specifically given permission to use the open space number 87 at the inner side of the railing within the campus of the Guwahati Market Complex, GMC Market Complex of Fancy Bazaar. This court, in view of the above, further made inquiries with Mr. S. Bora, the learned standing counsel, that if the land, if the multi-story building and the land encompassing the said multi-story building is specifically the property of the GMC, can any other person who have not been permitted be allowed to carry on any business therein? The learned counsel specifically stated that as the property in question specifically belongs to the GMC, permission to vend within the said campus can only be permitted on the basis of a permission to be accorded by the GMC. Upon hearing the learned counsels appearing on behalf of the petitioner, respondent standing counsel, upon hearing the learned standing counsel of the GMC, this court had further inquired with Mr. B. Gusami, the learned counsel appearing on behalf of the respondent number 5, as to whether any permission specifically have been given to the members of his members of the association whom he represents. The learned counsel submitted that there is already an order being passed by the coordinate bench whereby directions have been issued to the GMC authorities to make appropriate dated 29 2000 passed by the coordinate bench on 29 2019, whereby there is specific directions upon the GMC authorities to provide allotment to the members of the respondent number 5. Upon hearing the counsels appearing on behalf of the parties, this court have taken note of the provisions of the AMC Act, Guwahati Municipal Corporation Act 1971. It has to be done as per 104.
For 1 year.
We've also taken note of the provisions of the Guwahati Municipal Corporation Act 1971, which categorically mandate how the municipal property can be disposed of. Who categorically deals, and more particularly specifically section 104 of the said act, which deals with disposal of municipal property. From a perusal of the said provision, it therefore transpires that without there being any authority permission given by the authority, given by the commissioner, no person can vend within the campus of the Guwahati municipal property of the Guwahati Municipal Corporation. Taking into account the above, and the fact that the members of the petitioner association were given certain permission to carry on such vending, and specifically allotted spaces, comma. The GMC authorities taking into account the above, it is the opinion of this court that that without any permission or authority, the GMC authorities are required to take steps against those persons who carry on vending within the municipal property. Accordingly, the instant writ petitions therefore stands disposed of. Without such. However, this aspect would require carrying out certain verifications so that necessary actions can be taken by the GMC authorities. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. First, the Commissioner GMC is directed to carry out necessary verification as to who are the persons who have been granted permission to vend within the inner railing of the Guwahati Municipal Corporation Market.
Fancy with that, this is.
Fancy Bazaar.
Fancy Bazaar,
Within the
Fancy Bazaar, Guwahati Municipal Corporation Market.
in the Fancy Bazaar, so and so. Upon carrying out such verification and ascertaining those persons who have not been granted such permission, comma, this court directs the GMC authorities to take necessary steps again. Upon carrying out such verification, comma, the GMC authorities shall take necessary steps as envisaged in the law for eviction of those persons who have illegally trespassed inside the campus of inner railing of the Fancy Bazaar Guwahati Municipal Corporation Market. This court further observes that while carrying out the verification, the Commissioner GMC shall also issue a public notice asking all the vendors to place necessary materials to show that they have been granted such permission or not.
But may ending my position, my lord, if they take care with this eviction. Because other, in earlier occasion, eviction was done, but we are, cannot sit there. Say anything.
So, Guru, there is a difficulty in handing over the possession. I can say that it is further directed that pursuant to such verification, the GMC authority shall take necessary steps as required under law.
Fine.
Because why I'm not saying so? Because if I direct handing over which you don't have a license today, how do I do it?
Their license expired after 1 year. They came after expiry of their license. They were given temporary license.
This is, I am disposing it out, but the thing is, it's become very difficult, Mr. Burua. Unless you regulate, there's some regulation done by them. You see, the Street Vendors Act is much better. Street Vendors Act categorically says that you are to give them a particular area. It may be a case that morning they may be there, evening may be there. There is some regulation. Nothing is there. Anybody goes and sits out there.
First,
It reminds me of that initially Air Deccan came, no? So, you remember? No seat allocation, and you didn't have that, those areas at that point of time, what do you call, neither you had the bus or anything. So the moment you see the plane arrives, boarding given, immediately people used to run to get the first and last seats. So, and what are the other two?
Other to lawsuit proceeding another date.
The other two, the council appearing on behalf of the GMC submits that he requires some instructions in the matter. This is the matter after 4 weeks. Yes, what is this, Mr. Chaudhary?
Lord, I have a parcel land in front of me. There is a municipal road. There are total 5 petitioners, my lord. They
Huh?
have, the municipality has constructed a wall in front of my entry and exit. Others have got a relief, but the original petitioner was bedridden. He could not place his representation before the authority. So, my lord, his road has been blocked. He cannot come in. Ultimately, he expired.
Propose as to why weaken the nature of areas with. No, something specifically we should tell me.
Petitioner 225 has got relief.
Yes, where is the affidavit filed by them?
No affidavit filed.
You got an interim.
No interim. Only those
2 weeks time may be required to file a petition.
Hey, it's a own matter. Okay, your name?
Yes.
We need, you are appearing for a Silchar Municipal Board. Okay. And Miss So-and-so appearing on behalf of the Silchar Municipal Board. Takes 2 weeks' time for filing the affidavit. Is this matter again on 18th of December 2024. The affidavit will be filed by 16th of December without fail.
Item 9,
What is this?
We have received some instruction, my lord. And some more time is required, my lord. We are verifying the bills, my lord. Bills are earlier submitted, my lord. They are returned because these are my lord, whole bill, my lord.
Non-payment.
Yes, non-payment.
Non-payment, why? PWD.
No, my lord. No, my lord.
Is the deputy commissioner Gwalpara.
Deputy Commissioner work for my lord, concise related bill, my lord.
The so-and-so appearing on behalf of the district commissioner. Gwalpara
Work for my lord.
submits that some more time may be given for the purpose of filing, bringing on record the stand of the said authority. Matter again on 8th of January 2024. In the meantime, the affidavit will be filed without fail by 6th of January 2000. The council, the matter, if it comes back to me and you don't file, you know the consequence.
Yes, I have already communicated, my lord. Yes.
item 10 for order.
May I
Let me
please, your
please, your
lordship?
lordship.
Matter may be taken up at 2.
Last occasion, lordship, they have filed one additional affidavit. But in the
This was supposed to be taken up at 2 only. What is this matter about?
tender matter, lordship.
Huh?
Tender matter, lordship.
Tender.
Lordship.
What is this tender? For what? Stay, no stay. affidavits come. The action is the success shall be subject to the outcome of the petition. What is clause 14? You file your affidavits.
I have to file my affidavit because they, on last occasion, they have filed on that day one additional affidavit, Lordship. So some district administration has sought some more time to
Who?
district commissioner. to bring.
When are you filing?
Lordship, can it be on the first week of December? Fifth or sixth?
Huh?
Can it be on fifth or sixth?
5th, madam, 5th of December,
The record is there, it was called for, record is there.
because is
Record is there, some bulky, before that, Lordship, I want to file our affidavit, Lordship.
why haven't you filed?
Lordship, actually, our, in the main writ petition, our affidavits was almost ready. But on last occasion, it's upon 18, they have filed an additional affidavit. So we think it proper to bring on the Paravas comments in regard to the additional affidavit also in a.
Who filed the edition?
The petitioner,
When?
on 18. After 1811.
In 11.
Yes, Lordship. So it would be proper to bring on record the reply of that affidavit also.
Short date may be given because the term of the contract is actually over in March.
Fifth, Lordship.
Madam, 18th of you filed, so how can I hear it? We'll have it on 5th.
No, Lordship.
If possible, let's say earlier date, if possible, otherwise fifth.
Mr. Esa Purva, the learned counsel appearing on behalf of the district commissioner, will
Dhubri.
be submits that he has already prepared the affidavit. However, in view of the filing of the additional affidavit, he needs further make certain changes. And he then he submits that that in view of the filing of the Mr. Esabulwa, the learned counsel appears on behalf he submits that in view of the filing of the affidavit or edition affidavit on 18/11/2024, some more time is required for obtaining the instructions and bring on record the stand of the district commissioner Dhubri. Mr. So the learned counsel appearing on behalf of the petitioner expresses urgency in view of the fact that there is no interim order. Taking into account the above, lists this matter on 5th of December 2024. In the meantime, the affidavit be filed by the District Commissioner Dhubri on 4th of December 2000. Additionally, it is further directed that the records of the said tender process be placed before this court on the next stage.
Obliged.
What have you done?
Not,
Is your award?
not, now, since apparently the interest part was not considered, my lord. And earlier award, my lord, interest part was not considered, not now, we have to pay a new list, my lord, for that. And sometime.
And have you done? Where's the award? If you pass an award, then only things will happen.
Award statement, my lord, I have annexed, my lord, that. Like mark that award statement. My lord.
With the approval. Madam, you are entitled to how much?
I have no idea, my lord, how much money that is.
There are 6 petitioners, no?
My lord, and I would get to say that the my lord petition about who had expired, my lord, is 3 days ago, my lord.
What about the interest? Interest from when?
Wasn't it?
Section 6. First section 6 was done. 11/7/2023. Till date. Have you taken into account the interest?
That part, in that part, it was not done, we'll give it, my lord.
When?
But only the process is started, my lord. They are preparing that,
You have to pass the order, no?
pass it, my lord.
To pass the order, this is done under EI. So, madam, what do you have to say?
My lord,
Tell me. Is for this court only to decide orders. I have to help this court also.
because my lord, we are very poor villagers, my lord, and petitioner to all recent right, my lord, and 3 number also admitted in hospital, my lord.
So you are to pass an award in terms with section 11(3) of the Assam Land Acquisition and Requisition Act. Now, this refers back to section 11 of the 1894 Act. So you have to have an award statement. You have the book,
My lord.
Assam Land Acquisition and Requisition Act.
New act.
Give it to him. Hang on. You see, in terms with section 11(1), you are therefore required to determine the compensation. Okay, and now come to 11(3). So the award has to be similar in terms with section 11 of the act. Now, how is 11 Act award is made? Finally come to section 11 of the 1894 Act. Where is it? You have the 1894. Oh, no, 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 not in that book. A minute. Eleven, then down below, it says that with the approval of the state government. Isn't it? So you have to take the approval and then the award is to be passed. How much time? Who is paying for the revenue? Done the approval. They will send it. I'm sitting again on 17th. By that, produce the award. After the award, we'll take it. How you get the money. Pursuant to the order passed by this court on 19/11/2024, whereby this court inquired with the District Commissioner Dhemaji as to whether any fresh award and or supplementary award has been approved and filed before the office pursuant to the directions passed by this court on 15/5/2023. It has been submitted by Mr. G. Pegu, appearing on behalf of the District Commissioner Dhemaji, that an estimate has been prepared for an amount of rupees 3,24,85,785.58 and have been submitted to the Executive Engineer, Water Resource Department, Dhemaji, Division Dhemaji. Full stop. Be that as it may, taking into account that the collector is duly authorized under the provisions of the Assam Land Requisition and Acquisition Act 1894 to pass the award in terms with Section 11 of the Act of 1864, this court is of the opinion that the award has to be, the compensation has to be determined by the collector in terms with Section 11(1) of the Act of 1964. Further to that, it is also seen from a perusal of Section 11(3) of the Act of 1964 that the provisions of Section 11 of the Act of 1894 have been legislatively incorporated, meaning thereby that the award has to be made in terms with Section 11 of the Act of 1894. This presupposes, these provisions, a conjoint reading of these provisions therefore requires that the award which will be passed under the Act of 1964 has to be in terms with Section 11(1) of the Act of 1894 and would also require a approval of the appropriate government, that is the state of Assam, that is the Revenue Department of the government of Assam, prior to the same being filed in terms with Section 12 of, prior to the same being filed. In the office of the collector. However, from the materials placed by Mr. G. Pegu, nothing of such sort have been done. Accordingly, taking into account that certain estimates have already been made, meaning thereby a determination of compensation has been made, this court directs the District Commissioner, Dhemaji, to pass an award as per its determination, taking into account the provisions of section 26 to 30 of the Act of the Right to Fair Compensation and Hetu Lomba Economy 2013, for short the Act of 2013, as well as Schedule 1 to the said Act of 2013. This would include not only the market value of the land, as mentioned in section 26(1) of the Act of 2013, comma, the applicable multiplication factor in terms with section 26(2) of the Act of 2013, as well as 100% solatium in terms with section 31 of the Act of 2013, and the interest and compensation at the rate of 12% from the date of issuance of the notification in terms with section 6(1) of the Act of 1964 on the market value of the land in terms with section 33 of the Act of 2013. The District Commissioner Hemaji is directed to do the needful in terms with the above observations within 7 days from the date of the instant order, and thereupon the same be sent to the Revenue Department of the Government of Assam. Mr. A. Bhattacharjee, appearing on behalf of the Revenue Department of the Government of Assam, submits that upon seeking the necessary approval, the appropriate government would do the needful. This matter again on 18th of December 2024 and shown as parted. Then we can press.
Item 12 for hearing.
Your Lordship, I pray for short accommodation in this matter, as I have expressed my file yesterday. I pray for short accommodations, Your Lordship, because I misplaced my file, the file.
Why?
But yesterday I could not able to trace it out in my chamber. Pertains to refund of bank guarantee as well as the settlement charges.
This matter I've heard it earlier.
Yes, Your Lord. Yes, Your Lord.
Then what happened? At that time you had the file
Yes, at that time,
with you. Then,
yesterday I could not able to trace it.
hello, we impose a cost upon you, the 2% of the value. You'll be happy with that and give it to them.
With any kind of cost. It's tomorrow, Your Lord.
Am I going to wait for that for tomorrow? You lost the file, that is your responsibility. I'm not concerned. You impose the cost of 2% of the value and give it to them.
2%.
Over. You will be happy.
Yes,
That is
2%.
the only issue. The 2%. Could you have levied or not?
Yes, with interest. With interest. On no earlier occasion, I have.
That's the
paid
cost.
for-
No, you can't do this. And these are 2016 matters. Does it look nice on your part to say that I have lost the file? Doesn't it show the complete incompetency of yours? Don't mind me saying it, but it shows so. And that too, you know, that this court is very bad in granting adjournments. Then, even cost to, yeah. Thousand,
This has to be paid by me only because.
Huh?
Because of my fault, this can be.
so we impose the cost upon you to deposit. And when a bit, and that amount be deposited, and then only we will hear you at some time later on in all other matters. Don't be sorry. Somebody is suffering because of you. Is there a stay or not?
No, there's no, we have not paid for it.
Huh?
They have already levied and they have charged it and taken the amount from us.
They've taken the amount from
Yes,
you.
from a different account of mine, they have, without my knowledge, they have taken the entire amount. I kept on objecting, but without giving any reply, they just deducted the amount from another current account of mine. And that account, in that account, I had to deposit 1 crore. I've said it everything, 1 crore, because they have requested, it's on paper, we have submitted all the documents. They have requested that because of quarter end, they need some money. And being a good customer, old customer, they requested me to deposit some amount. And that's why on their request that I deposit in a different account, 1 crore. Immediately after I deposited it, they deducted it as a prepayment service in a different account. I have not alleged, but this is actually a fraud played upon me. Even though I have not alleged fraud, but this is actually a fraud played upon me, Your Lordship.
I think we need to pass a judgment in that regard.
Yes, Your Lordship.
These type of actions
Yes,
of the
actually.
ICICI bank
Yes,
should
Your
be resolved.
I am before Your Lordship, but I am sure
So that in future,
many have
such
already.
things does not happen.
Yes.
We further impose certain exemplary damages. It's a case of constitutional.
Yes, Your Lord.
You have asked for that damages.
No, Your Lord.
Think about it.
Only the
We should impose exemplary damages upon them. And why we should not refer it to the SEBI? Bank,
RBI.
who is in charge of the bank, which the
RBI,
ministry?
Reserve Bank of India.
Reserve Bank. And do you have any Reserve Bank circulars?
Yes, we have. Regarding
Say
fair
that
play
it
and
is not
everything,
permissible?
we have notifications.
Will refer for investigation with the ICICI. Let our investigation go with this Reserve Bank as regards this type of.
There is a strict guideline from Reserve Bank of India that everything should be very transparent, and while opening the account, in the very initial form itself, they will have to declare everything.
Is Reserve Bank a party?
Reserve Bank is
Ombudsman, banking.
Ombudsman is a
No,
party.
no, no,
Banking
Reserve
ombudsman.
Bank.
Reserve Bank is not a party. Banking ombudsman is.
No, no, banking ombudsman is too small.
Okay. Okay.
The
Ministry of Finance is a party.
Ministry of Finance is okay, but the Reserve Bank should have been made a party. And direction can be given to Reserve Bank to make an investigation into these type of things wherever it happens. It helps later on because of you, this ICICI Bank later on would not trouble other customers.
Okay.
It's Axis Bank.
Axis.
It's Axis Bank.
Huh?
Axis Bank, Your Lordship.
Axis Bank, ICICI Bank.
No,
No,
it's not
Axis Bank.
ICICI Bank. They have shifted their facility to ICICI Bank.
And that's why they have
Who
punished us.
imposed?
They
Your
imposed
Lordship,
Axis Bank. Axis Bank. Actually,
Bank.
what happened? Initially I had my cash credit account with SBI, so I transferred it to Axis Bank. And at that time, SBI didn't charge anything. Just they simply helped us in transferring the entire cash credit account to the Axis Bank. But thereafter, ICICI, we had a better offer from ICICI. When we wanted to shift from Axis Bank to ICICI, everything certainly in a very cunning manner, they made sure that we cannot shift and we stick to them. And that's why they have imposed all kinds of penalties in
But
cash credit
it is
account and
as per
also
the sanction of the
service
bank.
charges in bank guarantee.
It is as per the sanction of the bank. It is not outside the sanction of the bank.
No, not even that I can show. There are 3 sanction letters
initially the Reserve Bank of India very specifically in its guideline has stated that they will have to mandatorily put everything in the initial application form. They didn't. So in the initial sanction letter, there was nothing, not even a whisper about prepayment penalty, which itself proves that in the form itself, application form itself, there was nothing about prepayment penalty in cash credit account. Then there was a renewal. And they have stated on oath that if the renewal is delayed because of their fault, then also they can search penalty. On oath, they have stated that. And then they have renewed it 1 month prior the actual date of expiry. But at that time also, they didn't charge any prepayment penalty, even though it was renewed 1 month prior. Then on the next sanction letter, after the second sanction letter, they delayed it. And after 1 month of expiry of sanction, second sanction, they again gave me the third sanction. And in the third sanction letter, there was one sentence which shows that they can search prepayment. I have challenged them. This is my first line of argument. My second line of argument, even if we consider the dates will reflect your lordship, even if we consider that they are entitled to prepayment penalty, then also because of the dates, the account has been closed much later after the expiry date of the third and the final sanction letter. So there is no question of prepayment. That also I can show your lordship. Either way, they cannot charge any prepayment penalty. This is my case in brief.
Uh-huh.
And I have
This
another
is
thing
a
regarding the
petition pending for the last 8 years. The matter was heard substantially on 10/9/2024. However, on 26/9/2024, the matter got adjourned and thereby fixing the matter on 26/9/2024. On that day, the matter got adjourned and the matter has been listed today. The counsel appearing on behalf of the Axis Bank submits that he has lost the file. He has misplaced the file. It is relevant to take note of that the list was prepared 2 days. List was the list of today. The today's list, daily list, was published on, I think it
day before yesterday, Friday.
Friday, na?
Friday.
Was published on
22nd. of November.
22nd of November 2024. Therefore, the submissions so made by the learned counsel does not inspire the confidence of this court. It further shows this shows unprofessionalism. Be that as it may, as the adjudication of the instant matter has far-reaching consequences upon the Axis Bank Limited, may have far-reaching consequences upon the Axis Bank Limited, this court adjourns the matter to be listed again on 9th of January 2025. On the said date, no further adjournment would be granted. So it is made clear that in the meantime, the council, appearing on behalf of the Axis Bank, shall take appropriate steps.
Thank you.
13,
Like your lordship.
Hello, here, the National Highway has taken a stand, my lord, in their affidavit. Filed in additional affidavit, my lord, page 82, my lord. Opening page. National Highway has taken a stand that, my lord, the damage inquiry report that has been, my lord, prepared by the Revenue Authority, my lord, has been, my lord, now forwarded to the NC Hills
How can we decide?
No, my lord, thing is there, my lord, there is a change in circumstances they have brought, my lord. They are saying there is a damage assessment committee. National Highway, my lord, affidavit says that damage assessment committee has been constituted by the central government. And as per damage assessment committee, your lordship will see our names are also forwarded for release of compensation. Now the only issue is last occasion order, my lord, Revenue Secretary was directed of NC Hills to submit a status report regarding our my lord, regarding our assessment, reassessment, whether they are doing the reassessment or not. There is already an inquiry.
My lord, that's this matter. When we're constructing the road, this land is beyond ROW. Land right of way. There is a affidavit to the effect we have filed. It is the if any liabilities upon the concerned contractor, if beyond ROW any damage is caused. That is our strength. But what happened during pendency of the petition and this one are similar cases, number of affected persons came out. They have filed a division before the central government authority, higher authority to the ministry mill. Thereafter, it was handed over to ministry has given to Assam Chief Minister. Thereafter, for ends of justice, though it is legally may not be entitled, their committee is inquiring for this one assessment. Committee is with them, where near about 82 crores counts. But in the meantime, we have suggested to go and submit your application before their committee. But as he did not go, ultimately, from the honorable court, taking permission of this, I have perused this by that, okay, we'll send the name, your name, peace assessment committee. So that if you get from the government or whatever the authority, suppose some government is going to pay 82 crores or what.
Who is going to pay?
Government, I think, Assam government, this proposal is for 82 crores. I think this central government is entrusting to state government to look into the matter. Finally, it will decide. I think that is final decision will come whether how much payment. And nearly it has been as on 82 crores, something is coming up. Now, as we have forwarded their name to that committee, now I have requested personally him to at least inquire the matter whether your name is there or not. Whether because we have duly forwarded my affidavit clearly says, my lord, I have forwarded their name to assessment committee. That is why, my lord, last occasion our honorable court has passed an order. Okay, verify what is process of this, progress of that committee. Now BTC revenue will say, I think, on this point.
We have verified lordship. Petition number 4, 6, 7, 8, 10, and 12 are entitled to some damages lordship. And that we have also forwarded to some public works in and NH department. Assam
NH division.
PWD, NH division.
NH
we have
division.
forwarded it, lordship.
Then
They have forwarded. Is that clear? Thank you, Lord.
We have forwarded it to their lordship. That is my instruction. And further lordship, one of the petitioners have died also lordship. In the meantime.
some petitioners are entitled to,
Yes, yes.
some are not.
Come on now.
What is your inquiry report? Where is your inquiry report?
But
We
affidavit
have not-
respondent form, my lord.
We have not filed our affidavit yet.
File your affidavit. How much time?
2 weeks lordship.
These type of matters shouldn't at all be entertained. And they have already looked into it. It has been already taken up for the assessment. They are already looking into it. How can this court look into all these things?
If they suppose, my lord, they do not get or
It will be converting the high court into either a reference court or a civil court.
that is taken by the authority concerned, right or wrong. But now, if they have grievances on that, they have to come by other means. Now, right, I put or legal from other firm that will be.
Because this is outside the ROW.
Minor.
It is outside the ROW.
That
If it is
you,
outside the
that is 100%.
ROW, the
It is
question
100%.
is whether National Highway will pay or not, or whether the payment will be made by the contractor. These are all questions of
Yes,
facts.
yes,
And maybe sometimes, government also, public power interest, Assam government also will be considering. Assam government has got lots of money. Because sometimes our our chief minister may think it's public interest. So we like this. But that is this the court, the forum for
Right.
that? Court cannot go beyond that. Once this is over by this submission, I think it is over. Mr. C. Sharma, appearing on behalf of the NC Hill, submits that an inquiry report has been, he has already been served with he have furnished with an inquiry report, whereupon, from where it is seen that some of the petitioners would be entitled to, have been recommended to be entitled for assessment. Full stop. Taking into account the said stand, let an affidavit be brought on record along with the said inquiry report by the NC Hills. NC Hills. Full stop. List this matter again on 18th of December at 2 p.m. Full stop. The inquiry report, the affidavit be filed by 16th of December. I'm putting it at 2 p.m. Otherwise it won't reach. Because if you bring it, Mr. Sharma, I'm telling you, once you bring that, I can dispose it off out there so that the petitioner will take appropriate steps for that. I have nothing to do. This court can't look into all this.
Item 14,
What is this?
Item 14, your lordship, kindly go to 12-9 order, lordship. Hereby, lordship, we have been directed to get certain instructions, whether lordship, there is a mistake on our part, lordship, where we have not sent the letter, lordship.
Yes, what is your stand?
Lordship, that instructions, lordship, we failed to send the letter, lordship. It's a mistake on our part, lordship.
Isn't it a simple question? First of all, you can't disturb the position. They applied for Mission Bosundara, and then you are not accepting because of the pendency of the report. Isn't it? Hello? But as per that order, which has been passed on 18/6/2019,
Alternative arrangement, I have said, lordship, I have.
they cannot be disturbed unless till you make.
Lordship.
So their application has to be taken into account that we dispose it off.
In that case, lordship.
Your
by the
problem,
way-
because of the pendency, you have not done. Now the question is, you have already, they cannot be disturbed. So they will remain in occupation in view of that order. And you consider,
their cases under the Mission Bosundara, lordship, in that case,
isn't it? Why do we need to keep these type of matters pending?
lordship.
Or you want it?
We want to dispose of earlier also.
So you cannot be disturbed your possession
Lost.
in view of the
Yes,
18/6/2019 order. However, your application for Mission Bisundara is not being taken because of the pendency of the writ petition. So we dispose it of. Take it. Win-win for both sides. Heard Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, and Mr. H. Sharma, the learned counsel appearing on behalf of the district administration,
2, 3, and 4, lordship.
district
Lordship,
district administration,
yes,
and revenue is there,
revenue is
and Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the revenue department of the government of Assam. It is seen from a perusal of the order dated 18/6/2009, passed in WPC number 43954/2002, that this court, that the coordinate bench of this court had directed, had observed that as the petitioners are indigenous, landless, flood-affected people, and as well affected people, and in terms with the land policy adopted by the state government in 1989, the petitioners deserve consideration for settlement of appropriate land in their favor. It was further observed that the state government, the coordinate bench of this court further directed the state government to make alternative arrangements so that the petitioners can be settled in any other government land as indicated in the order dated 5/6/2002. It was further mentioned that observed that till such arrangement is made, status quo order passed by this court on 12/7/2002 would continue. Paragraph 6 of the said order is reproduced hereunder. It is seen that the petitioners herein, pursuant thereto, have applied for settlement. Further to that, the petitioners had also applied under the Mission Bosundara scheme during the pendency of the writ petition. The applications so submitted by the petitioners under the Mission Bosundara, however, have not been accepted as submitted by the learned counsel for the petitioner on the ground that the instant writ petition is pending. This court have duly heard the learned counsel appearing on behalf of the petitioner as well as the counsel appearing on behalf of the respondent authorities. From a perusal of the judgment and order passed by this court on 18/6/2009 in WPC number so and so, it is clear that the petitioner's possession cannot be disturbed by the state government unless alternative arrangements are not made. It is also seen that the petitioners have duly applied for settlement and have also settlement. However, such applications have not been brought to its logical conclusion in view of the pendency of the instant writ proceedings. Accordingly, the instant writ petition therefore stands disposed of, thereby directing the respondent authorities to consider the applications so submitted by the petitioner for settlement as per its land policy of 1980, as per its present land policy. It is further observed and directed that till the petitioners are given alternative accommodation of settlement in other government lands, the petitioner's possession over the lands shall not be disturbed in view of the observations so made by the coordinate bench in its judgment and order dated 18/6/2009.
Item 15 to 19.
What is this? What are these matters?
My lord, in this case, earlier I filed the petition, but later on the petitioner took brief from me, 15 to 19, and they have engaged another set of counsel. So my name may be struck off from the Wakala, from the cause list.
What are these matters, Mr.
To the government, the IOCL had acquired certain land in Betkuchi, Guwahati for augmentation of the terminal, PG terminal. The acquisition, we have constructed and completed the boundary walls also. The other extension work is also, as per my instruction, is complete. Now, during the acquisition process, they didn't come before this board, neither did they file any objection before the government. And now straight away they have filed the petition deeming ingress and egress or saying that you acquire my land also because from your acquisition, the ingress and egress to my land has stopped and I have become landlocked.
The requisition has to be dismissed, not maintainable at all.
My lord, in fact, this court bench has dismissed exactly similar method and the appeal is currently pending before a
No, let another appeals be also pending. Because of the fact, first, I cannot impose the state for the purpose of cannot impose the state that you kindly give him the ingress and egress to a private party. You are a private. You have acquired the land by paying compensation. So your ingress and egress is already there. Whether they have got the compensation or not, that is for them to settle. That their land has become invaluable, for which they should have gone file reference court or whatever, maybe they could have done that. They have not challenged the award also. Athens. So the land rests upon you. Secondly, this court can't direct the state to acquire your land.
And we are not in need of any other, we are not in need of more land, my lord. We have stated that in our application.
Okay. How many cases?
15 to 9.
From I thought 15 to I think 19.
Yes, what do you have to say? Who are you? Who?
And I'm for,
You are appearing on behalf of?
1819.
You are appearing on behalf of?
The senior counsel after the course.
Ready.
And we need some time to reconstruct the file.
You need time for?
Reconstruct the file as 1 week time may be granted as we have.
For what? The only solace I can give you is to write such a long judgment. This is 2-paragraph judgment.
Exactly in the same footing. Exactly in the same footing.
Isn't it? So,
In fact, when these matters were filed in 2015, getting wind of these matters, they approached this court in 2017, 17 and 18. 18.
where is your senior?
Yes, Your Lordship.
Which court?
Your Lordship, he is on sessions for some.
Huh?
For sessions for some cross matters.
Sessions court. My goodness. This is the importance he gives to the matters in the High Court.
Your Lordship,
And I don't grant adjournment for senior counsel. This is my policy. Can't help it, you argue.
can we grant 1 week time so that we can.
1 week? You ask for 1 minute, I'm not granting you. Forget about a week.
The humble request, Your Lordship.
No case. This is covered, Judge. Covered. No, nothing. That too, these people have questioned the land acquisition proceedings also in the earlier case.
But it was their submission, my lord. It has been recorded. It was their submission, not pleadings. In fact, the senior government concept was also heard.
And this was done under the old Act, New Act. Was it done under old Act, New Act?
Lapsed and we moved on to 2013, so we have compensated under 2013 Act.
Was it under the new act or the old act? Payment of
New Act.
compensation is different. Whether it was acquisition done under old act or new act.
New Act. New Act.
New act. So then you have to apply 105. 101. Where is the new act? But why they are making reference to 49 then?
Because there's some, that was what observed in the judgment, my lord, it was their submission. So it was.
Where is the right to fair compensation act? No. What to do, Mr. Bhardwaj? We give her some opportunity.
Let her live to die and let her.
When was the acquisition started? Let's see.
2000.
You know, but these cases are different. They've taken money also.
That they are silent, but we have taken that stand in the affidavit. Each of them are silent whether they have.
And they have filed application for enhancement of compensation also. Isn't it? What remains? What remains here? So right to fair compensation. You have only paid as per the new act.
But, page
When was the acquisition started?
2011.
Oh, this is the old act. The old act, only the 26 to 30 applies, nothing more than that.
But the notice sent to the
So
individual.
therefore,
petitioner-
the single judge was referring to 49. And as per the Indore Municipal Development Authority, the question of returning does not arise. So they has to go for an acquisition. Now the question is, how can this court impose the state to acquire? And I'll further direct you to relieve. All matter. Mr. Jain, what are you teaching the junior counsel? Yes, Mr. Jain. You
I
were
am
the
not in the case.
person who brought this case.
I'm not in the case.
But you were there.
The brief, they took brief.
Huh?
Judgment.
What judgments?
Now, I don't
There's no judgments out there.
think
And there is no judgment out there.
Now, out of the court, I may submit that in one case of the similar nature, this court has directed me to appear before the deputy commissioner collector,
Before the,
for the purpose to this subject matter of this.
how? How can the court direct? Show me a provision by which the court can direct you to approach the collector. What is the collector going to do? He has no business.
So he is the acquisition authority.
So what? Once the acquisition is done, it
He
is
is the
over.
acquisition authority, he acquired the land on behalf of the ILC.
So what? Hardly matters. Can he do it?
No, but the,
Mr. Jain, kindly appreciate one thing. Kindly see. Section 4 notification is issued by the appropriate government. Section 6 declaration is made by the appropriate government. And by Section 7, the collector is permitted to take over the charge. So he becomes an agent. Once the acquisition is being done, completed, with the filing of the award under Section 12, the business of the collector is over. He has no business. Show me any provision by which he has any business except under 28A. Yes, Mr. A. Bhattacharjee, you are an expert on land acquisition. Tell me.
Once he has done his part, the word is done. It becomes fantastic.
Some court may pass it, but not me.
but you know,
it would be the 100 years before your
Okay, tomorrow, 2 o'clock. tomorrow, 2 o'clock. Matters have been substantially heard. List this matter tomorrow at 2 o'clock.
My name may be struck up because there's another set of lawyers.
Or name, where is your document to show? Where have you filed your affidavit? You continue to remain unless you show me an evidence that you are no longer
And they
there.
have already handed over brief to another set of lawyers,
Who?
my learned friends.
So don't appear. Tomorrow at 2 o'clock. Ask your senior to be present. Mr. Birdwell, take this.
M20,
What is this?
This is relating to the termination of a CIPF constable. There are a series of litigations in this regard. There is a series of litigations. It starts from 19.
You have been terminated.
Yes, but now that has been modified to compulsory retirement.
Compulsory retirement. So,
So
what is
I've
the
given a list of dates.
No, no, it's okay. Now you are in compulsory retirement. Why you are challenging it?
Without any benefit, because I was terminated, because I will not get any benefit out of that because I have not completed that period of service.
So can there be a compulsory retirement without reaching a particular age?
Lordship, because
By way of penalty,
earlier it was removal from service.
by way of penalty, it was imposed.
Earlier it was removal from service. Thereafter, after this division bench has set aside that order and directed to give us a without removal. So compulsory retirement.
Huh?
Compulsory retirement has been given.
Give me the division bench order.
Lordship, division bench has not said that.
He says so. Let us hear.
To pass any order other
Single
than
bench has
Page
passed
46.
an order.
The page 46, it starts from page 46.
Yes, division bench order, na?
Lordship, I have given
We say
list of date.
we have duly considered while we do not find any ground to interfere with the order of the learned head to the extent of quashing the order dated demand. Passed after giving due consideration. We find merit in the submit reconsideration not be preempted by it has to be as per law and take to judicial review in case the same is found to legality. in court. So what did the learned single judge division bench say?
Page 50 is the
So the
order.
order was set aside.
Is that penalty order was set aside, and page 50 is the relevant portion that was set.
And it was
Page 50 last two paras. Having regard to the level of
So now you have given a different
compulsory
name,
compulsory retirement.
with the same impact.
name. but you remove the same.
Lordship, there was another writ petition thereafter. This division bench order, thereafter, there was another writ. petition.
Not a repetition.
I have prepared a list of that because there are series of writ petitions in this case. So. Lordship, that again on 17/11/2011, after this division bench order, they have imposed the penalty of removal from service. That was challenged in writ petition number WPC number 1363 of 2012. An order of that was disposed of by order dated 8/2/2013, that is at Annexure 8, page 59. Operative portion is at page 66. It is relied upon the division bench order. Para 6, page 66. Then against this order, the writ appeal was preferred by the respondents. Then writ appeal was disposed of. That order is at page 7. Here, and relevant
Oh,
portion
no,
is
no,
page
no,
7.
kindly come to 103. Upon so and so, and as per the CCS pension rules, by rule number here, he is also eligible to full compensation package pension and retirement gratuity as admissible to him on the date. Now you are not entitled to it.
No, because I have served only a few months. Because in 1996, because this started from 19.
We do one thing. We do one thing. As the removal has been set aside
Yes, Lord.
by year, the period during which you have been there till 2017 be taken into account.
Yes, Lordship, that is I am asking, because now I don't have anything more. That should be counted for my
Because these
pension
have been
liability.
held to be illegal,
Yes, Lord.
removal, so you are in service.
Yes, Lordship.
So under such circumstances, this order remains, but that will be, this period will be
That
counted.
is because other relief I will not get, because reinstatement at this stage is not possible. Even I have attained the age of superannuation, normally I would have attained the age.
Because you see, you have removed. But the removal has been set aside. The moment the removal has been set aside, he is back into the service. So the period from so and so will have to be taken into consideration. Isn't it? What do you say, Mr.?
Lordship, that is I am asking, because that is,
So that is your entire relief.
yes, Lordship.
We are seeing the petition action. When was the so-called notice issued? 96.
Yes, Lord.
And you joined when?
Lordship, not
94.
96.
From 94.
Yes, 94.
So 94 to 2017 shall be counted.
Yes, Lordship, that is the base relief I can get. Because reinstatement at this stage, because I cannot go undergo training and I have already out of the employment for so long. And now probably I have attained the age of superannuation. So it is not possible. If that is counted, I'll get the benefit of pension. That is,
So is it the pension which will this compensation pension, full compensation pension?
yes, Lordship, counting that period, whatever is entitled, I am entitled to.
So can we take it that pursuant thereto, you have not been granted any pension?
Yes, Lordship. I have not been granted. I have been informed
So
that I
that is your grievance.
Be-
What is your grievance? Is your
My
grievance
grievance is
against the
that
compulsory retirement or against non-payment of pension?
No, Lordship, this is against my compulsory retirement because what the court has observed. They give some punishment lesser than the removal from service. The impact of the punishment that has been imposed.
And the penalty has been removed, set aside
Yes, Lordship.
every time.
Yes, Lord. This court has set aside time and again. Once it was dismissal, that was set aside. They came with removal from service.
that was set aside. Now they came with the compulsory retirement. The impact of compulsory retirement, they have changed the terminology, but the impact is same because I am not getting anything. Even if in the compulsory retirement, as because I have not I have not completed the qualifying service on the 2006. So I will not get anything. 2007, sorry. I will not get anything. They
So
have
we
not-
will take your argument. Is there any basis of your pleadings on that? That the removal having been declared to be illegal all along. So you would be wanted as from service from date of your appointment till the date of compulsory retirement.
Yes, Lord.
Is there a statement in your pleadings?
Probably there may be.
If that is there, it helps you. Otherwise, you kindly file a short affidavit on that. Somewhere you find.
Lordship.
If it is
Probably-
not there, bring it by way of a short affidavit.
Yes, Lord.
Because you are challenging the compulsory retirement.
Yes, Lord.
Just file a short affidavit. I think, Mr. Counsel, you bring this aspect by way of an affidavit.
I'll file a short affidavit that will help.
We keep it as part heard. Then only things.
Yes, Lord.
Otherwise, matter will go when it will.
Yes, Lord. Yes, Lordship.
What do you say, Mr. Lee?
Yes, otherwise it goes.
These matters needs to be finished off as early as possible. How much time do you require?
Lordship. By Friday, I will file. On Monday,
I'm not there 2 weeks thereafter, nah?
Lordship, in the next Monday.
We can have it on 16th
Yes, Lord.
at 2 p.m.
Yes, Lord.
Heard Mr. So-and-so, the learned counsel appeared. And Mr. S.S. Roy, the learned central government standing counsel. The petitioner herein have assailed the order dated 4/1/2017, whereby the petitioner was imposed the penalty of compulsory retirement from service with effect from 6/3/2007. The counsel appearing on behalf of the petitioner admitted that in the meantime, the petitioner have already submitted that on the earlier occasions, the penalty so imposed upon the petitioner was penalty or so imposed was for removal of service. So this removal, the penalty for removal of service was duly interfered with by this court, thereby setting aside the imposition of penalty. So it is only, however, it is only on 4/1/2017 that too, with effect from 6/3/2007, 17, a 7. It was only on 4/1/2017 the punishment of compulsory imposed retirement was imposed from service, that too with effect from 6/3/2007. The learned counsel appearing on behalf of the petitioner submitted that when the penalty was imposed only on 4/1/2007 of compulsory retirement, it could not have dated it back to 6/3/2007. Was the same on the face of it was illegal and arbitrary. It further, the learned counsel further submitted that the said actions on the face of it also shows the arbitrary nature, arbitrary actions so taken by the respondent authorities. The learned counsel, however, submitted that he would like to file a short affidavit in this respect. List this matter again on 16/12/2024 at the top of the list. Was the affidavit be filed by 12, by, no, filing by 10/12/2024. With advance copy to the council, to Mr. S.S. Roy, the learned counsel appearing on. Matter be shown as part of it. Finish. What are the other matters?
Item 22.
In item 22, the brief has been handed over today to additional AG Mr. P. N. Muswami Lordship on his behalf. We seek some time to apprise this court.
Your Honor, I'm praying for the petitioner, Your Honor, the earlier engaged counsel has withdrawn his wakalatnama, N.J. Khatonia, and
Now you are appointed. What is your name?
my name is Bonita Chaudhary, B. Chaudhary.
E. Chaudhary.
Yes, Your Honor. I'm praying on behalf of Midul Kumar Bora, Advocate Midul Kumar Bora.
Who is he?
He's
He's a lawyer in Guwahati.
in Guwahati, Your Honor, High Court. He's practicing High Court, Your Honor.
The lawyer in Guwahati.
Yes, Your Honor. Midul Kumar Bora.
Is so-and-so appearing on behalf of the petitioner submits that she has been recently engaged by the petitioner in the matter and as such requires some time for preparing the matter.
Plus to file wakalat. File wakalatnama.
What?
We have not filed wakalatnama yet. So we have 1 week time to file wakalatnama.
There is no wakalatnama filing or no, you file whatever you feel file like in the meantime. List this matter again on 7th of January 2024. So in the meantime, the council, so the learned counsel for the petitioner shall prepare.
23.
Yes. Opponent wants to take time.
Lordship, this is a case of downgrading. We have challenged the entire procedure.
Huh?
We have challenged the entire proceeding which is vitiated.
You have challenged the entire?
Downgrading, reduction in rank.
You want to file the affidavit now, Mr. Datta? Is it in this case?
Lord, I think the record, we produced the record, that record is with us. In fact, this officer
What happened? What is the punishment given?
reduction from scale 2 to scale 1.
Very good. What did you do?
Lordship, nothing. Even the person in whose reference I have been reduced, this is the second round of writ petition.
Hmm.
Earlier, order was set aside and remanded back for passing speaking order.
That there is no reason, but here they say that although everything is true, but I am not interfering on the basis of the fact that you have done something action which is malafide. What is the
Lordship,
meaning?
then the facts are to be thrashed out in that case. Lordship,
So we have it some other day.
in the month of January. In fact, this is a case of removal from service. He has been given lesser punishment.
Yes, we are involved in some money.
Yes, customers' money, my lord, has been misappropriated. by him. No,
But
lordship,
the
not
money
at
has
all.
been recovered is immediately. It's a
That's
bank.
immaterial.
It's a
Misconduct
bank
will be.
after all.
And he has been recovered. This is a case of double jeopardy, Lordship.
No, no, no.
Once by Chief
How?
Manager Vigilance, then after 1 year, the impugned.
No,
discipline.
no, how double jeopardy? You have been to the jail. Under jail. Where is the double jeopardy?
The law is very clear, my lord. The appeals court has said, if you return the money along with interest, the misconduct remains.
Then, law is very clear. What to do? Dismiss.
No, Lordship, we have to argue for it.
Yeah,
But
I
if
think it's
if
that
not
one.
today, Lordship, then some other
Hello.
day we fix.
No,
In the
there's
first
no
week of-
case for argument. Okay, this matter again on 21st of January 2025.
Obliged.
The request of the petitioner,